In today's video, I'm talking about the Party Wall Act of 1996, what it is, what work it covers, and how it might apply to you. But first of all, if you're new here, please don't forget to like, comment, subscribe, and hit the bell icon, because that not only helps my channel grow, but it helps you stay in touch with new legal videos. And big thanks to everybody that contributed names for our fictitious land in which to base our stories, and to everybody that voted. There were lots of votes, and so bigger thanks still to Tony Strange for contributing Lawchester, which has emerged certainly as the biggest favourite so far. So today we've got Mr. and Mrs. Casey down in Lawchester, and they want to do some work on their property. They want to rebuild part of the kitchen and extend the garden wall from that point onwards. The problem they've got is that it borders directly onto a neighbouring property. This is where the Party Wall Act kicks in. You see, a party wall is that which stands on the land belonging to two or more owners, and it may form part of a building and it may not, such as a garden wall. If this garden wall is right on the boundary between two properties, then it's considered to be a party wall. A party structure could be part of a floor or some other structure that separates two buildings, such as flats, for example. And important to remember that party agreements are different from planning permission and they are different from building regulations. So Mr. and Mrs. Casey have just moved into this property and it's got a really old and decrepit kitchen on the back of it, and they want to essentially take a good chunk of this down and rebuild it. It's that bad. And in doing so, they've got this huge wall outside, which is far too tall. It blocks all the light, and they want to knock that wall down or at least reduce it in height. The Party Wall Act 1996 is a statutory framework that allows neighbours who share a boundary to carry out various types of work. So let's say Mr. and Mrs. Casey have popped along to see me because they've had a disagreement with each other as to whether or not they have to tell their neighbour about the work that they're planning to do, and whether or not they need permission from their neighbour for the work that they're planning to do, either as part of the kitchen or as part of the garden wall that they want to reduce the height of. You must tell your neighbour if you plan to build on or at the boundary of your two properties. You must also tell your neighbour if you plan to work on an existing party wall or party structure. So that covers here Mr. and Mrs. Casey's kitchen and the wall that they plan to reduce the height of. It would also apply if you had to dig below or near the foundation level of either property. So my first questions to Mr. and Mrs. Casey about the kitchen would be, is it necessary to do any major works on the walls of the kitchen, or are they just replastering, putting in new sockets, new cupboards and things like that? If that were to be the case, then so far as the kitchen goes, that would be fine and they don't have to tell them about that kind of work. The Party Wall Act is not designed to allow a neighbour to prevent work from being carried out on your property. It's more a case of when and how those works are carried out. Because after all, if it's going to have an effect on the neighbouring property, then it's only right that there is some say as to how and when this happens. So now Mr. and Mrs. Casey throw a bit of a curveball at me. They tell me that the neighbour has actually moved out already, and the new neighbour, whilst has contracted to buy the property, hasn't yet completed and bought the property. So their question is to whether this prospective owner of this neighbouring property should be informed. Thankfully, this is covered in section 20 of the Party Wall Act, which describes a building owner as someone who has a substantive legal interest in the property, and it can include prospective owners, such as the case of Mr. and Mrs. Casey's soon-to-be neighbour. So with building ownership, there are various rights and obligations which are set out in this statutory framework in the Party Wall Act. These include, at the very least, to give appropriate notice in accordance with the Act. Secondly, that the works are to be carried out within a 12-month period of giving such notice. It also provides for going on to the neighbouring owner's land, providing notice of at least 14 days is given. It also quite obviously provides for exercising reasonable care when carrying out the works, minimising the inconvenience and compensating the neighbouring owner for any damage that's caused to their property whilst carrying out the work. Failure to comply with the Party Wall Act is a breach of statutory duty, thus it should be taken very seriously and thus losing protection from the Act, which can give rise to claims for nuisance and trespass. So now Mr. and Mrs. Casey are wondering who they should give this notice to, which parts of the work they need to give notice for, and what that notice looks like, and in other words, how long that notice should be. So first of all, as I said, a building owner is described in the Act as someone who has a substantive legal interest in the property. So this would include both the current owner, because that person still owns the property, but also the incoming prospective owner, because that person has contracted to buy this neighbouring property. although hasn't yet bought it, has contracted to buy it, so therefore has a legal interest in the property. Mr. Casey, being very eager to do lots of work on this because he's done a bit of building work himself, decides he wants to take the whole thing down and effectively rebuild it. He says the insulation is rubbish and he wants to rebuild the whole kitchen, which includes the wall which borders directly onto this neighbouring property. Mrs. Casey's primary interest is in the garden wall. Currently it stands very tall, blocking all the light, and she wants to reduce its height so she can see over the nice countryside down in Lawchester. She also wants to extend that wall on with a new section that doesn't currently have any wall on it. So quite clearly, notice must be given to both the existing owner and the prospective owner in respect of the work to the kitchen, the work to the existing wall, and the work to the new wall which doesn't yet exist. Sections 2 and 3 of the Party Wall Act deal with the notice for existing walls and structures, and these require 2 months' notice before the work commences. Whereas building a new wall or party fence wall requires 1 month notice. As I said earlier, a party wall is that which stands on the land of 2 or more different owners. With Mr. and Mrs. Casey's property, it's a semi-detached property and the wall sits directly between the two, and the centre of the wall runs right into the middle of the two semi-detached properties, dividing the two. This is much more likely to be a party wall. But I would always recommend to get a party wall surveyor so that you know for sure as to whether you need to serve notice. Now, Mr. Casey tells me that he's spoken to the existing owner and the new prospective owner, and they don't mind him doing the work. However, Section 3 of the Party Wall Act requires that oral consent is to be confirmed in writing. Now, you may be wondering, what's the point of giving notice under the Act so that someone has time if the neighbour can't prevent the work from being carried out anyway? Well, as I mentioned earlier, there is some sort of protection in the Act in what we call the Remedies section, which is Section 10 of the Party Wall Act. Mr. Casey feels quite insistent that he just wants to get on with the work and doesn't want to waste time with serving a notice, since they've already agreed that he can do the work. However, as I said, the consent must be in writing, and failure to serve a notice, or the correct notice, or on the correct recipient, will be a breach of the Act. Obviously, my firm advice to Mr. and Mrs. Casey is that they cannot just get on with the work without serving the appropriate notices to the appropriate people. One of the remedies available to the neighbouring owner and prospective owner is to seek an injunction of the court to prevent commencement or continuation of the works if he just starts the work. If Mr. Casey's completed the work without serving a notice and before any court action, the owner and prospective owner can still claim compensation for his failure to comply with notice requirements under the Act. So whilst a little bit disappointed that he cannot just get on with the works, Mr. Casey is thankful of the advice because otherwise he may have landed himself with either an injunction or a claim for compensation, so he sets about instead for serving the appropriate notices and instructing a surveyor to come out and look at the wall to determine whether or not it is in fact a party wall outside. In the case where the neighbour has already indicated his consent to Mr. Casey, this is not the same as consent under the Act. Consent under the Act can only be given once a notice is served. So Mr. and Mrs. Casey should still serve notice for the works, and then the neighbour will have 14 days to indicate his consent in writing. Obviously, the notice should be dated. It should contain the names of all the owners, including joint owners, so Mr. and Mrs. Casey, the address of the property, a full description of the works that they intend to carry out, including diagrams and things like that, if that's going to help understand what the work is. And obviously the date that they intend to commence the works, but obviously this can't be before the expiry of the required 2-month notice period. Once Mr. and Mrs. Casey have served this notice, there'll be a 14-day period in which they can receive written consent, they can receive a refusal of consent for the works, in which case it will engage the dispute resolution procedures, or they may receive no response at all, which is taken to be dissent and will also trigger the dispute resolution procedures. Examples of notice letters and of written consent can be found in the government's explanatory booklet, which I will link below. The neighbours might serve a counter notice within that 14 days on Mr. and Mrs. Casey, suggesting that additional work is required to that they've proposed. If Mr. and Mrs. Casey agree to this, again within the following 14 days, they can provide that consent in writing in exactly the same way. If all of this is agreed with written consent, the work can start. If there is no response within the 14 days or a response refusing consent, then a dispute is said to have arisen. In the event of a dispute, they should appoint an agreed surveyor or a surveyor of their own to draw up between them an award. If the two surveyors can't agree an award between them, they will select a third surveyor, and between them they will agree an award, and then the work can start. As you can probably tell, this is a very complex area of law with lots of caveats and pitfalls, and I would always suggest that you discuss openly and friendly with your neighbours about any work that you want doing before it's done, because it's far easier to agree these things up front than it is to fight and argue about them afterwards. So as always, I'm going to link below to a lot of great resources so that you can read a lot more about this area, and I would always suggest that you get legal advice if a dispute has arisen or is likely to arise, so that you know exactly where you stand on any of the works that you wish to carry out. So another day in Lawchester, another neighbouring dispute prevented before it starts. Let me know in the comments names of future couples or individuals who've got trouble in Lawchester, and don't forget to subscribe, like, comment, go crazy, and I'll see you next time.